$25 million, 4 years of delays, settlement talks completely collapsed, and now Erika Jayne has run out of time. After securing one final delay, her fraud trial is locked for May 2026, with no more extensions allowed. This is the complete breakdown of what's happening as the clock runs out. If you've been following Erika Jayne's legal nightmare, you know it's been a roller coaster of delays, denials, and desperate attempts to avoid trial. But as of March 2026, the game is over. Erika has secured her final delay, and the jury trial is now locked for May 19, 2026. No more continuances, no more postponements. After nearly 5 years of litigation, Erika will finally face a jury over the $25,592,261.26 that Tom Gerard's law firm allegedly spent on her lifestyle while stealing from vulnerable clients. Today, we're breaking down everything that's happened, the settlement talks that collapsed, the designer lawsuit that's making things worse, and what Erika is really facing when she walks into that courtroom. Let's get into it. Let's start with where we were just a few months ago. In December 2025, attorney Ronald Richards, who's been closely following this case and representing creditors, posted a bombshell update on Instagram. Settlement talks have broken down completely between Erika Jayne and the trustee. He wrote on December 24, 2025. A motion was also filed to gut any remaining defences she had due to admissions in the Sila case. Pre-trial hearing is less than 30 days away, with a 21,026 trial date, now a real thing. Erika has little options, panic sitting in. That post confirms several critical things. First, Erika and the bankruptcy trustee, Alyssa D. Miller, had been negotiating a settlement to avoid trial, but those negotiations had completely fallen apart. Second, admissions Erika made in a separate lawsuit with designer Christopher Pye were now being used against her in the $25 million case to eliminate her defences. Third, the trial was set to begin February 10, 2026, just weeks away at that point. The court documents Richard shared showed a joint status report listing the pre-trial conference for January 21, 2026 at 1:30 p.m. and the trial beginning February 10, 2026 at 8:30 a.m. The trial was expected to last between 7 to 10 days, meaning Erika would spend over a week in court testifying, being cross-examined, watching evidence be presented to a jury about how she spent $25 million in money that allegedly belonged to Tom Gerard's clients. For context, these weren't just any clients. Tom Gerard's law firm, Gerardi Keith, represented widows whose husbands died in a plane crash, burned victims from a gas pipeline explosion, orphans whose parents were killed, and other vulnerable people who were owed settlement money. Instead of paying them, Tom allegedly stole their money and used it to fund his and Erika's extravagant lifestyle. Tom was convicted of wire fraud in August 2024 and sentenced to 87 months in federal prison, which is over 7 years. He's currently serving that sentence. While Tom faced criminal charges and was convicted, Erika has never been criminally charged. But the bankruptcy trustee filed a civil lawsuit against her for fraudulent conveyance, which is a legal term that basically means she benefited from stolen money, whether she knew it was stolen or not. The law allows trustees to claw back money that was transferred fraudulently, and Erika received $25 million over 12 years from 2008 to 2020 for her company, EJ Global. The details of the $25 million in spending are absolutely staggering. According to the trustees' lawsuit, over $14 million was spent on American Express charges made by Erika on cards issued directly to her. Another $1 million went to vendor payments made exclusively for Erika's benefit. The expenses consisted largely of costs to promote Erika personally, meaning her pop music career, her glam squad, her designer clothes, and her lifestyle documented on Real Housewives of Beverly Hills. The trustees' lawsuit alleges that Girardi Keys, Tom's law firm, paid all of Erika's personal and business expenses between 2008 and 2020. That's a 12-year period where Erika allegedly never paid for anything herself. The firm covered her glam squad costs, which were astronomical given that she had a full team doing her hair, makeup and styling for every appearance. The firm paid for designer jewellery and luxury items. The firm funded her music career, including recording costs, music video production, and promotional expenses for songs like XX Pentive and How Many. Erika's defence has always been that she didn't know where the money was coming from. She trusted her husband. She wasn't involved in the law firm. She had no reason to believe anything was wrong. Her attorney, Sir Evan Borges, has stated that Erika never worked at Gerard Kaiser and never received even a penny from the transactions at issue. He's argued that her biggest mistake was putting trust in her then-husband. And the trustees' lawsuit amounts to senseless bullying and piling on. But the trustee argues that doesn't matter. Under fraudulent conveyance law, whether Erika knew the money was stolen is irrelevant. She benefited from it. The law firm paid her bills. She lived a lifestyle funded by money that should have gone to clients. Therefore, she has to pay it back. The trustee also points out that Erika signed or authorised every charge made on those American Express accounts. She approved vendor payments. She knew money was flowing to EJ Global from Gerard Keys, and if she didn't know the source was stolen client funds, and she knew her company was receiving millions from Tom's firm. What made Erika's situation exponentially worse in late 2025 was a separate lawsuit from fashion designer Christopher Pauser. Sila sued Erika for $18 million, claiming she falsely accused him and his company, Marco Marco, of making nearly $800,000 in fraudulent charges to her credit card without her authorization. Erika had reported these charges as fraudulent, essentially claiming Pila and another designer, Marco Moranti, had stolen from her. But Sila fought back with evidence showing Erika had authorized the charges and received the items. He accused her of using her powerful connections, including her husband's relationship with Secret Service agents, to try to get away with not paying for designer clothes she'd purchased and worn. In October 2025, and Erika lost her SLAPP appeal in that case. A SLAPP motion is a legal manoeuvre to get a lawsuit dismissed early by arguing it's a meritless case designed to silence free speech. When Erika's SEA PPPP motion was denied and her appeal failed, it meant the case would move forward to trial. More importantly, attorney Ronald Richards revealed that admissions Erika made in the Silo case were being used against her in the $25 million bankruptcy case. Whatever she said under oath or in court filings about authorizing charges, receiving items, or how money flowed through her accounts was now evidence in the trustees' lawsuit. Those admissions gutted her remaining defences. According to Richards, additionally, Marco Moranti, the other designer from Marco Marco, filed a separate case against Erika in Florida. Earlier in 2025, she was facing a $300,000 default judgment in that suit, meaning she didn't respond properly and lost by default. Between the Sila case, the Morante case, and the bankruptcy trustees case, Erika is facing potential liability exceeding $43 million. That's $25 million to the trustee, $18 million to Sila, and $300,000 to Morante. Throughout 2025, Erika attempted multiple times to settle the $25 million case with the bankruptcy trustee. In September 2025, Ronald Richards posted that she had a full day of mediation on September 22nd that was being reset for October 7th. Maybe she will finally cough up some money, he wrote. Then in October, he confirmed settlement negotiations were ongoing, but warned that Erika could either roll the dice and risk insolvency or work out a principled settlement. On the defence that Tom kept the books and she didn't know about the ledger or accounts is a loser, Richards explained. She received $25 million for nothing. Funds received like this get clawed back in a bankruptcy case. Her state of mind is irrelevant. That assessment was brutal but legally accurate. In fraudulent conveyance cases, the recipient's knowledge doesn't determine liability. What matters is whether they benefited from money that should have gone to creditors. A source told the US Sun that Erika was never going to settle and would stand trial to clear her name. Whether that's bravado, stupidity, or genuine confidence in her defense remains to be seen. What complicates any potential settlement is the creditors. These are Tom Gerard's actual victims, the people owed money from settlements he stole. Even if Erika and the trustee agreed on a settlement amount, any creditor could object in bankruptcy court if they believe the deal shortchanges victims. Some creditors might prefer to see Erika forced to pay the full $25 million rather than accept a discounted settlement. The bankruptcy court would have to approve any deal, adding another layer of complexity. As the February 10, 2026 trial date approached, Erika made one final desperate move. On February 2, 2026, attorney Ronald Richards announced on X, formerly Twitter, that Erika Jayne is desperately trying to hold off the trial. She has gotten the trustee to agree to a continuance to April 14, 2026. She is providing documents relative to her finances. The parties have told the court, "This is the last continuance. Yet any settlement may be opposed by any creditor in the bankruptcy court." The court documents Richard shared showed the new timeline. The deadline for filing second-round pre-trial documents was continued from February 4, 2026 to April 15, 2026. The final pre-trial conference and all motions in lemon, currently set for February 18, 2026, were continued to April 29, 2026 at 1:30 p.m. Most importantly, the jury trial was continued from March 10, 2026 to May 19, 2026 at 8:30 a.m. And the order explicitly stated no further continuances will be requested. That last line is critical. This is the final delay Erika will get. The court made it clear that May 19, 2026 is the date, and there will be no more postponements regardless of what happens between now and then. Erika's legal team, led by attorney Evan Boris, signed off on this schedule, meaning they agreed to these terms. They're out of runway. The trial is happening. Why did Erika get this delay? According to Richards, she's providing documents relative to her finances. This suggests ongoing settlement discussions or discovery exchanges where the trustee needs more financial information from Erika to assess her ability to pay. It's possible Erika is trying to demonstrate she doesn't have $25 million and can't afford to pay it back. Or she might be showing what assets she does have to negotiate a realistic settlement amount. Even if Erika offers everything she has, if creditors think it's not enough, they can block the deal. So the bankruptcy court would have to weigh whether a guaranteed settlement amount is better than the risk of going to trial and potentially getting nothing. If Erika wins or declaring bankruptcy, if she loses when Erika walks into court on May 19, 2026, she'll face a jury trial expected to last 7 to 10 days. The trustee, Elisa D. Miller, will present evidence showing that Jayne Keys paid $25,592,261.26 to Erika and EJ Global over 12 years. They'll show American Express statements with Erika's charges. They'll present vendor invoices for Glam Squad services, designer clothes, music production costs, and luxury items. They'll demonstrate that Tom's firm was paying these bills while simultaneously stealing from clients and not paying them their settlements. The trustee will argue that under California's fraudulent conveyance law, these transfers must be returned to the bankruptcy estate so victims can be compensated. They'll point to the timeline showing Erika received millions while clients were being defrauded. They'll use admissions from the SA case showing Erika authorized charges and received benefits. They'll argue her state of mind is irrelevant because she was unjustly enriched by money that belonged to creditors. Erika's defense will focus on her lack of knowledge and participation. Her attorney will argue she's an entertainer with a 12th grade education who never worked at the law firm and trusted that her husband and the outside accountants were managing finances properly and lawfully. They'll point out that at Tom's criminal trial, the government never claimed Erika did anything wrong, and neither side called her as a witness. And they'll argue she was a victim of Tom's scheme, just like his clients, unaware that the money funding her lifestyle was stolen. The problem for Erika is that none of that matters legally. Fraudulent conveyance isn't about criminal intent or knowledge. It's about whether money was transferred that should have stayed with creditors. Even innocent recipients who had no idea money was stolen can be forced to return it in bankruptcy. But Erika's best defense is probably that she doesn't have the money anymore, so the court can't force her to pay what she doesn't possess. But that's an admission of insolvency and could lead to her filing bankruptcy herself. The jury will have to decide whether the trustee proved the elements of fraudulent conveyance, that Girardi Keys transferred $25 million to Erika, that those transfers were made while the firm was insolvent or became insolvent as a result, and that Erika didn't give equivalent value in return. Given that Erika never worked for the firm and provided no legal services, the equivalent value element seems impossible to prove. The trustee will almost certainly win on the facts. The real question is the amount. Will the jury award the full $25 million? Will they reduce it based on some calculation of what Erika actually received versus what went to third parties? Will they consider her current financial situation and ability to pay? Bankruptcy judges have discretion in these matters, and the judge could structure a payment plan or settlement that's realistic based on Erika's assets and income. This brings us to the critical question: does Erika even have $25 million to pay? Yeah, the short answer is almost certainly no. Since divorcing Tom in November 2020, Erika has been living in a rental. She left their Pasadena mansion with virtually nothing. She's documented on Real Housewives of Beverly Hills that she had to downsize significantly, sell belongings, and adjust to a much less lavish lifestyle. Erika's income comes primarily from Real Housewives of Beverly Hills, where she's been a main cast member since season 6 in 2016. Veteran RHOBH stars reportedly earned between $500,000 and $750,000 per season. Over 10 seasons, Erika has probably earned $5 million to $7.5 million from Bravo before taxes. Snorts. After taxes, that's maybe $3 million to $4.5 million in take-home pay over a decade. She also earns money from performing. Erika has a cabaret-style show where she performs her pop songs at venues and events. And she's appeared at venues like the Mohegan Sun in Connecticut alongside other artists. But cabaret shows at smaller venues aren't generating millions in income. She might earn $10,000 to $50,000 per show depending on the venue and ticket sales, so maybe a few $100,000 per year from performances. She sells merchandise or has done cameos and monetizes her social media to some extent, but none of these income streams are generating the kind of money needed to pay a $25 million judgment. If Erika has been living off her Bravo salary and performance income while paying for rent, legal fees and basic expenses, she probably has minimal savings. Her legal fees alone over the past 5 years must be astronomical given multiple lawsuits, appeals, and now a trial. If Erika loses at trial and is ordered to pay $25 million, she'll almost certainly file for bankruptcy protection herself. That would trigger another bankruptcy proceeding where her assets and income would be examined, a payment plan would be structured, or she'd discharge the debt entirely if she qualifies. Creditors could garnish her future Real Housewives paychecks and performance income, potentially taking a percentage of everything she earns for years. The worst-case scenario for Erika is losing at trial, being ordered to pay the full amount, and then being forced into bankruptcy, where she loses control over her finances. She might have to liquidate any remaining assets, lose her ability to work certain jobs, and spend years under bankruptcy court supervision. The best-case scenario is winning at trial, though that seems unlikely given the strength of the trustee's case. So a middle scenario is losing, but negotiating a reduced payment plan based on her actual ability to pay. As of March 2026, here's where things stand. The trial is set for May 19th, 2026, with no more delays allowed. Erika must file second-round pre-trial documents by April 15th, 2026. The final pre-trial conference is scheduled for April 29th, 2026 at 1:30 p.m. Then on May 19th, jury selection begins and the trial starts. Between now and May, Erika's legal team will continue preparing their defense, gathering evidence, and possibly attempting settlement negotiations. The trustee will finalize their evidence and witness lists. Both sides will file motions in limine to exclude certain evidence or arguments from trial. The April 29th pre-trial conference will address any outstanding issues and set final ground rules for how the trial will proceed. Once trial begins, it will last 7 to 10 days. The trustee will present their case first, calling witnesses and introducing evidence of the $25 million in transfers. Erika's team will cross-examine witnesses and try to poke holes in the case. Then Erika's defense will present their side, likely calling Erika herself to testify about her lack of knowledge and involvement. The trustee will cross-examine Erika, which could be brutal given all the evidence against her. After both sides rest, the jury will deliberate and reach a verdict. If they find in favour of the trustee, they'll determine the amount Erika must repay. If they find in favour of Erika, she walks away owing nothing. Though that outcome seems extremely unlikely, the verdict could come in late May or early June 2026, depending on how long deliberations take. If Erika loses, she'll have options to appeal, file for bankruptcy, or negotiate a payment plan with the court's supervision. If she wins, the trustee could appeal the decision. Either way, this saga probably won't be fully resolved until late 2026 or even into 2027, given how slowly the legal system moves. After 5 years of delays, Erika Jayne is finally out of time. The May 2026 trial is locked with no more extensions, $25 million, a collapsed defence, and creditors demanding justice. Whether she knew or not, the money has to go back. Subscribe for trial updates as this unfolds.